Hello, I'm Abby, and this is my friend, Tato.
I'm subbing for my cousin Jeannie. Jeannie has a runny nose.
Achoo!
That's her in the background. She has bad allergies.
I hope Jeannie gets better. Meanwhile, Tato, today you and I are going to go over the Supreme Court's ruling in the case Jones versus Mississippi.
Righto! In a 6-3 decision on April 22nd, 2021, the court ruled that courts do not have to find minors permanently incorrigible before sentencing them to life without parole.
Before we go on, let's give a quick definition of permanent incorrigibility. It refers to an incapacity to change. Incorrigible means something, usually someone, can't be corrected, and that they're set in their ways.
This case is a serious one. It began in August 2004, when 15-year-old Brett Jones killed his grandfather. He was convicted of murder and sentenced to life without parole.
That was the mandatory sentence at the time. Shortly after the verdict, however, court rulings significantly reshaped juvenile sentencing. In 2005, the Supreme Court ruled that the death penalty is unconstitutional for minors.
Then, 2010, it prohibited life sentencing for juveniles in all non-homicide cases. Homicide is when one human kills another.
In 2012, the court struck down mandatory life sentences without parole for minors in the case Miller versus Alabama. States could still sentence minors to life without parole, but they couldn't be mandatory punishments.
In Miller, the court established 5 factors for courts to consider before they can sentence a minor to life without parole. They are, first, the minor's age and immaturity; second, the home environment; third, the circumstances of their offense; fourth, disadvantages they faced in the justice system, for example, challenges participating in court; and fifth, the chance of rehabilitation.
Miller also seemingly held that life sentences without parole should be reserved for rare cases where the minor demonstrated a permanent incapacity for change. 4 years later, the court ruled that Miller could be applied retroactively, meaning it could be applied to past cases, like Jones's. This was in the case Montgomery versus Louisiana.
After these rulings, the Mississippi Supreme Court, Mississippi is Jones's home state, voided Jones' life sentence and ordered his resentencing. At court, a past employer of Jones testified that Jones was a good and mature worker, that he got along well with others. Jones' lawyer argued this showed that Jones was capable of changing, for the better, and that he could be rehabilitated.
Mississippi Circuit Court Judge Gardner disagreed. He ruled against Jones and resentenced him to life without parole. He considered the 5 factors the court established in Miller, but he didn't decide whether Jones was permanently incorrigible.
So Jones appealed. The Mississippi Court of Appeals ruled against Jones, and the Mississippi Supreme Court rejected Jones's appeal for further review. Jones appealed to the Supreme Court, which agreed to hear the case in March 2020.
At the Supreme Court, Jones's lawyer, David Shapiro, argued that permanent incorrigibility should be the deciding factor when sentencing a minor to life without parole. He argued that permanent incorrigibility is a substantive rule.
Wait, Abby, what's a substantive rule?
A substantive rule is retroactive, meaning it applies to past cases, and it deals with the who and what in a case. It decides who can be convicted, of what crimes they can be tried, and what punishments they can receive.
Okay, Mississippi's lawyer, Christy Noble, argued that permanent incorrigibility is actually a procedural rule. Now, a procedural rule deals with just that, the procedure. In this case, it decides how defendants are tried. Noble argued that permanent incorrigibility is one factor of many that the judge can apply to decide whether to sentence a minor to life without parole. However, it's not a deciding factor.
Fast forward 5 months, and we come to the court's decision. The court ruled against Jones. Writing for the majority, Justice Brett Kavanaugh held that courts do not need to decide whether a defendant is permanently incorrigible. However, they do need to consider the defendant's youth before they sentence minors to life without parole.
This doesn't mean states can impose restrictions on juvenile sentencing. In fact, Many states have prohibited life without parole for minors, or required courts to decide whether juvenile offenders are permanently incorrigible. However, Kavanaugh maintained that those issues are for the states to decide, not the Supreme Court.
Kavanaugh was joined by Chief Justice John Roberts and Justices Samuel Alito, Neil Gorsuch, and Amy Coney Barrett. Justice Clarence Thomas wrote a concurring opinion, where he challenged the court's decision in Montgomery. That's the case where the court ruled that Miller could be applied retroactively to previous cases.
Now we get to the dissent. It was written by Justice Sonia Sotomayor and joined by Justices Stephen Breyer and Elena Kagan. Sotomayor argued that the court's decision violates precedent, specifically the decisions made in Miller and Montgomery, but will be focusing on Miller.
Sotomayor said courts ignored the central issue in Miller. Miller, she contended, draws a line between minors who are going through a stage of immaturity or recklessness and those who are irreparably corrupt. Because courts didn't decide what she considered to be a key factor, Sotomayor maintained that Jones should be resentenced.
So what happens to Jones now?
In Justice Kavanaugh's majority opinion, he wrote that the court's ruling is far from the last word for Jones. Jones can seek relief through state legislatures and courts, or through the state governor. If that fails, he can seek conditional relief, but he won't be considered until he's 60.
There's one thing, though. 25 states now have bans on juvenile life imprisonment. 6 more don't have anybody serving a life sentence for a crime they committed when they were a minor.
If Jones is unsuccessful in the courts, turning towards his state legislature could be an option. On a broader scale, though, the court's decision will probably make it harder for minors to challenge life without parole sentences.
And that's a summary of the court's ruling in Jones v. Mississippi. I think Jeannie needs a new box of Kleenex. Got to be going.
Meanwhile, thanks for watching. See you next time.